Okay, welcome to Chapter 3. We're going to be talking about court procedure in this chapter, basically the process whereby a civil lawsuit proceeds. So the first thing to understand is, like any complex procedure, there have to be rules. And there are rules about a number of different areas. So one of the areas is evidence. There are what's called the FREs, the Federal Rules of Evidence, and for the state of North Carolina, the North Carolina Rules of Evidence. And this would govern what material would be admissible, would come into court, would be heard, but doesn't cover everything. It's just addressing the evidence, so it kind of exists as a separate part. The next big block of rules are the procedural rules. So you have the North Carolina Rules of Civil Procedure and the North Carolina Rules of Criminal Procedure. These are both codified bodies of law that set up how you move forward. They are integrated to some extent with the rules of evidence, but they're a little bit broader in scope. We also have, of course, to understand that there's a really multi-stage process whereby something winds up in civil litigation. It's not as easy as you see on TV, nor is it as common. It's a very long, very complex process, and we're gonna touch on many of the things about it, and in the next. But also be aware that there's a lot of informal stuff that goes on. Okay, so here's really the first kind of informal thing to look at, and that's, do you want an attorney? Now, obviously, there are instances where you can represent yourself, famously small claims court, but there's a legal adage that anyone that has themselves for a client, representing themselves, has a fool for a client, because it's difficult to wear multiple hats. I think it's hard for a attorney who's schooled in the law to do this. I think it's impossible with any sort of hope of victory, I guess, put it that way, for someone who is not schooled in the law. So you're going to get yourself an attorney. And remembering that attorneys have gone through 4 years of regular school, 3 years of law school. They're probably going to specialize, most likely in civil or an area of civil, like they might just do torts, they might just do contracts, they might just do wills, or criminal. And again, you could specialize in drunk driving, you could specialize in tickets. Once there's a specialization, and there are still GPs, particularly in smaller towns and small locations, attorneys do everything, they don't work for free. They have to earn a living. They have to pay for all that education. They have to pay for that office, those suits. So how do they charge? Well, there's really kind of three ways. One is a fixed fee. And this is done for relatively simple things that you, as an attorney, have a pretty good idea of how long they're going to last and what they're going to do. So I'll make up like writing a will. That's sometimes a loss leader for a law firm, but it's also something that's heavily standardized, assuming that it doesn't require a trust or a living trust, or there's not a lot of complexities to it. You might say, okay, I will write you a will, and usually do a power of attorney, and usually do a living will in North Carolina, what's called the Declaration for Desire for a Natural Death, for, say, $300. If there's something that the attorney doesn't know how long it's going to take, he might say, well, I will charge you an hourly fee. And I would say kind of the low end of this typically would be about $125 an hour. Now, again, there are exceptions to this, But if you're talking about anything that might lead to litigation, you're looking at 100 to 125. And the upper limit there, depending upon what you're specialized in, you know, some of the most expensive private attorneys are ones that have multiple degrees and work in multiple fields, like ones that are patent attorneys, so they often have engineering degrees, or they're medical malpractice attorneys, and some of them actually will have medical degrees. So that can be really expensive. That can be $500, $600, $700 an hour, or thousands of dollars an hour. The other way, and this is more common in certain types of civil lawsuits, is a contingency fee, where you go into an attorney and you say, okay, I've got this case, it's a slip and fall case or a broken bone case, and I'd like to sue, and the attorney says, well, you're poor, you can't pay me. You can't pay me a fixed fee because you don't have the money. You can't pay me an hourly fee because you don't have the money. So I will take this on contingency. So let me give a quick example of how that works. Let's suppose that you had, we'll just make up a number, $10,000 of medical bills. And you came into an attorney. And it depends on the nature of the bills and a few other things, but let's just suppose your total damages were $10,000. But not your pain and suffering, not incidental expenses. So I might sue for $30,000, which is 3 times the amount. Usually it's between 2 and 3 times the amount. It depends on some factors. Let's suppose it's 3. All right, so $30,000 is recovered. Let's suppose you win. You're probably saying, okay, great. I get 2/3 and the attorney gets 1/3. Well, that's true. The attorney's going to get 1/3. But, and here's the big thing, if an insurance company, a medical insurance company, has paid out damages, they're going to put their hand out and they're going to take their part. So if there were $10,000 in medical bills, we're just going to say they're all covered, then $10,000 is going to go to Blue Cross Blue Shield. And then $10,000 is going to go to the attorney, and then you're going to get $10,000. Now, there are certain costs that can't be paid by the attorneys. Filing fees, certain out-of-pocket expenses, they've all got to be covered. And this is, some of these service fees and court costs are really put in place to prevent attorneys from just starting baseless lawsuits. The biggest reason I think you look at hiring an attorney is you have to make certain decisions about what am I going to recover versus what is it going to cost me. Now, in a contingency fee, that's not as big a consideration because most of the time and effort is the attorney's. And if you win $1,000 or $10,000, you're still going to get some. But if the attorney looks at it and says, this is not going to go well. I don't want to take it as a contingency, but I'll take it as an hourly fee. You pay me per hour, or a fixed fee. And almost all criminal cases are hourly fees or fixed fees. You really got to weigh whether you want to go forward, because the attorney, and the best attorneys you can get are the ones that look at you and say, yes, something was done. Yes, you were harmed. Yes, it's a terrible situation. No, you shouldn't sue, and here's why. And the major reason not to sue is that you're not going to recover enough money, and you're going to spend more time and effort than it's worth. So again, sometimes it's just not worth it. And that's really something that has to be decided. Okay, so the first thing that we're going to talk about is the pleadings. First thing you have to decide about is you're going to have to draft the complaint. I'm going to show you a picture of one of those in a second. But this initial document, the complaint and the summons that's attached to it, the complaint lays out the basic framework of what went on. So it'll establish jurisdiction and venue. So you'll say, okay, I'm suing in the North Carolina courts. I'm suing in the Wake County Superior Court. Then in North Carolina, we have what is called notice pleading. You have to hand this complaint to someone, they have to read it, and by reading it, they should be able to basically understand what happened. You don't have to have everything, not every witness, not every event, but enough for someone to look at it and say, oh, okay, this is a slip and fall case, or this is an automobile accident case. The basic facts. Then you're going to have to state damages. Now, sometimes that's limited. Sometimes you can't put the total damages in there, and they're subject to revision. But what are you asking for? Maybe you're asking for money. Maybe you're asking for a injunction. I don't want you to do something, or an injunction to do something. You also have to state what is your legal theory under which you're suing, your cause of action. So is it a breach of contract? Is it a tort issue? What is the reason you can sue and hope to win? So this is a copy of a complaint, and you can see here, I'm not sure you're going to see the arrows, it's called a complaint. It would be in the District Court of Wake County. It'd read something like State of North Carolina, County of Wake, District Court. Here's the plaintiff, here's the defendant. It's going to establish jurisdiction, okay? This is where they're a resident. This is the defendant being a resident. And then it gives you certain basic information. That's what one looks like. So once you've drafted the complaint, here's where it kind of changes a little bit. If I'm going to sue someone and I know they're represented by an attorney, I'm in all probability going to call them up and say, hi, John, this is Jay. My client, Bill Jones is suing your client, Susie May. Will you accept service? Will you, as the attorney, accept the complaint? And 99 times out of 100, they'll say sure. Sometimes they say, go ahead and put it in actual service of process. If that doesn't exist, the primary thing I do is I go and I get the complaint stamped. A copy goes in the file. Copy is established. I keep a copy of the stamped file. Then I take one and I staple a summons to it. And I walk over to some of this can be done electronically, obviously. These are kind of like just laying it out as if it's a geographical thing. I walk over to the sheriff's office, and they will have a division that serves papers. So I will pay them, and again, different states have different numbers, $10, $8, $20, whatever it's going to be. You give them, say, $20. They take that piece of paper, the summons, and the complaint that's attached to it, and they give it to a deputy. That deputy gets in his car. He drives out to the person you're suing's house. He knocks on the door and says, are you John Jones? Yeah, I am. Great, we're suing you. Or you're being sued. Here's a piece of paper, you're served. Now, you can also do this in some cases by newspaper publications, certified mail, and even having a private party serve it. One of the things that's important to know is that this is the beginning of a lawsuit. And if you get one of these things and you ignore it, you rip it up, depending upon the time frame of how it works, 30 days later, if you've been properly served, I could go into court, and you won't be represented. I could go into court and say, I want a default judgment. They failed to appear, they've been properly served, they didn't bother to reply, I win, they lose. And the judge would probably grant it. Well, what do you do about corporations? And this is one of the practical tips here that's important for small business owners to know. When you file your articles of incorporation, and we'll talk about business organizations in another chapter, but when you file your articles of incorporation, which sets up your company, you have to file this document with the North Carolina Secretary of State, your articles of incorporation. And in that, you have to name a registered agent. Now, one of the things I recommend to clients is either use a service or pay attention to this, because you say, oh well, 10 years ago I set it up, my old buddy was kind of in business with me. We put his name down as registered agent. He moved to Alaska. I run the company now myself. Well, guess what? Secretary of State still has his name, his address here in North Carolina. He's moved to Alaska. I go to sue that corporation. I send the service, I send the complaint to him. He comes back, he doesn't live there anymore. I can serve the Secretary of State saying they didn't change the registered agent, they may or may not be able to get up with you, or they may or may not have a process to get up with you. And again, default judgment can be triggered. All right, after you get the complaint, there has to be an answer, which is the document that is prepared, and it's in many ways a mirror of the complaint. Same headings at the top, talks about jurisdiction, talks about venue, will contain additional facts. Again, they don't have to be complete. It can, at this point, raise certain defenses. Like in a criminal case, it might raise insanity, or it might be a statute of limitations is run, or a statute of repose. There's different defenses. One of the things that's very common in the answer is to raise a counterclaim. To say, oh, you're suing me for $10,000 for an injury, but it was your fault, and I'm out $10,000, so I'm going to sue you back. This is helpful because it, the old expression is, the best defense is a good offense. If you can put the other side on the defensive, if they have to think about, well, do I want to go forward, because if this lawsuit continues, I could not only lose, but I could wind up owing money. So it's very common that we put a counterclaim in there. The next stage is where most cases are won and lost. You make some motions. Frequently someone sues or is sued, and it's a garbage lawsuit. So you might make a motion at that point to say, Your Honor, I'd like you to dismiss this lawsuit. There's no basis upon which relief can be granted. Or you can look at the pleadings and instantaneously tell what the result is going to be. So give me a judgment of the pleadings, or give me a summary judgment. And bad lawsuits often die right here. However, it's the next process where you engage in discovery. So it's discover. But discovery is the process whereby each side finds what evidence, what witnesses the other side has. So it's not like TV, where you say, oh, I have a surprise witness, or I have surprise evidence. It's not going to fly, because you're going to have months between filing a lawsuit and going to trial, whereby you're supposed to tell the other side all the evidence you have. And if you sit down at trial after 6 months of discovery and you haven't given that evidence to the other side, it's not going to be admissible. So what kind of evidence is discovered? Well, depositions. This is a very common way. You take people's testimonies under oath. You have a stenographer, or you have a recording. Someone sits there, they're asked questions, they have to answer the questions, it's under oath. If they lie, they're subject to perjury. They have to answer. Now, sometimes they can't physically be there, so you might send them written questions. Again, these are called interrogatories, they're under oath. It's just as if they were testifying, but they're doing it in writing. You may want to frame the issues, and this would be a request for admissions. Like, let's suppose nobody's in their complaint or answer said what time of day the accident occurred. You might say, we'd like you to admit or accept as fact that the accident occurred on October 22nd, 1994 at 4 p.m. or between 4 and 5 p.m. And they might say, sure, we'll admit that. And that really clears out unnecessary stuff. You can ask for production. So this is physical evidence. This is very important because physical evidence, x-rays in personal injury cases, can be much more important than testimony. People can lie. Physical evidence can be misinterpreted, but it's real. You can also ask for examination. You know, someone says they're crippled for life. You can say, well, I want a doctor to examine them. And of course, there's electronic discovery. As I tell or told clients, you're fish swimming in an electronic sea. You live and die being photographed by CCTV, by interacting with your phone, by interacting with the ATM or the point of sales or all this stuff. Electronic discovery can be very important. You can even see that you need, at a certain point for electronic discovery, an expert. Can be critical, can be expensive, but it can be critical. Okay. Are you going to go to trial? No. Only about 2% of cases go to trial, so it's pretty rare. Most of the time, you, first of all, you don't file a lawsuit. You write a letter, you make a demand, they don't agree, you drop the case. If you do file a lawsuit, it often ends right there. You do discovery, you find out there's no money, you just decide not to go forward. If you do go forward on the day of the trial, there may or may not be a jury. Now, it's not automatic. Criminal cases, unless you waive it, it kind of is, but in civil cases, it's not automatic. If you're going to have 12 people decide issues of fact, now they don't decide the law is decided by the judge. You've got to select a jury. So there's a pool of potential jurors. It's called the venire, V-E-N-I-R-E. This is drawn from, in the bad old days, it was just property lists, and it was just white men. But it's broader now. It's things like voting lists and driver's licenses, a whole 9 yards. So you get lots of people to come in. And you put them on a panel, and you ask questions. So sometimes you can ask them a question, could you ever find for the plaintiff? And they might say, no, I would never find for a plaintiff. Well, they're prejudiced. They've prejudged the case. In that case, they can be dismissed. Sometimes they have a conflict of interest. Okay, Acme Ball Bearing is being sued. Where do you work, sir? Work at Acme Ball Bearing. Well, we're going to dismiss you. But sometimes you're going to dismiss someone preemptory because you feel that he may be able to be fair, but he's going to lean to the other side. So you have a limited number of those. That's called a preemptory challenge. Okay. This is where the federal rules of evidence come in and the North Carolina rules of evidence. There are three great gatekeepers. Is evidence relevant? That is, does it matter? Is it competent? Can we trust it? Is it material? Is it important enough to hear? So it can be expressed in different ways. Is it fair? Is it reliable? Is it competent? But to be admitted, it's got to be relevant. It's got to matter. It's got to prove something. And one of the big stumbling blocks is, let's talk about not hearsay. Well, it is hearsay, but heresy. Let's talk about hearsay. Very often people go to court and they say, what did the defendant tell you? And the guy says, well, the defendant said that he wasn't going to pay me because he tricked me into signing the lease or something. Okay. This is essentially one person telling you what another person said. The general rule about that is it's not admissible. However, there are 27 exceptions to that rule, which really means that hearsay very often does get in. But it's something that we question quite a bit, and it was worth a kind of a separate diversion. Okay, we do the opening statements. Tell the jurors what they're going to hear. You identify who you are, you identify your theory of case, you go forward. The plaintiff then starts direct examination. He calls his witnesses, and he's not supposed to lead at this point. No leading questions. They're presumptively okay on cross, but not on direct. You begin direct examination. Tell me a story is basically what happens here. They tell the story. Now, at this point, you get to cross-examine because all good stories are just that. They're stories until you can kind of pick them apart. Like, people tell stories about Bigfoot and Chupacabra and UFOs, but when you start to ask questions, very often these stories will fall apart. So, oh yeah, I saw a UFO. They give you an interesting story. You say, oh, that sounds pretty credible. Then on cross-examination, you say, were you drinking? No, but I was doing mushrooms. Oh, you were doing mushrooms and you saw aliens. Okay. The cross-examination really reveals more of the truth. All physical evidence is admissible through witnesses unless you stipulate. So generally, any piece of physical evidence, any contract, anything like that, to get it in, you either stipulate you're going to admit it, or a witness has to bring it in. Plaintiff goes, defense goes. At the close of all that, you have motions and then closing arguments. Tell them what they just saw. Each side summarizes it, and then the judge tells the jury, here are your instructions. Now, they have the right, if they want, to ignore everything. They can go back in that jury room, do whatever they want. And it happens sometimes. It's called jury lawlessness. They then, in a civil case, have to prove, or is proved to their satisfaction by a preponderance of the evidence. And I use the example 51 to 49. That's not technically correct, but it's a way to look at it. Criminal trials are different. You have to prove beyond a reasonable doubt. But in a civil trial, 51 to 49, that yes, by a preponderance of the evidence, it is likely that the plaintiff or the defense was correct. Very often, too, they decide on damages. After the trial, there's frequently time for motions. Sometimes, rarely, the judge will set aside the verdict. Very often, they reduce damages. Sometimes you'll ask for a directed verdict. Again, very, very rare. That's overturning the thing completely. Now you have to decide, do you want to appeal? You're not happy with the verdict or the damages, and you appeal. If it's a criminal case and the state loses, there's a not guilty, there's no appeal. That doesn't happen. Although they can appeal if a conviction is thrown out on appeal, so they can appeal to a second appellate court. So what do you do when you file an appeal? Well, first of all, you file a motion within a set time, and you say you're going to appeal. You are now called the appellant. You're called the appellate. You then send a request to the upper court. This is called a brief. To ask that they request all the records. You can include pleadings. You can include trial transcripts, motions, arguments, verdicts, the whole 9 yards. Each side files a brief. Remember, they're only arguing issues of law here. They cannot argue issues of fact, because appellate courts hear violations of the law, not the fact. Judges now look over the brief, and they've got 3 big options. They can affirm it. They can say, oh, no, the lower court was right. Go on about your lives. They can reverse it. Oh, no, we're going to send it back down. They were wrong. Or they can remand it. They can send it back down and say they were partially wrong. We want you to charge us a little bit of the thing. If you win, so you sue somebody civilly, you win, you get a award of, say, $10,000, and the other side says they're not going to pay. Well, in North Carolina, what you do is, again, you go to the clerk of court's office, you file what's called notice of rights exempted, you give them 30 days to exempt certain property. If they don't, 30 days after that, you go and file a writ of execution. You take that, you go over to the sheriff's department again. They send 2 deputies out who seize goods and sell them at the sheriff's auction. And now some assets are exempt, like wheelchairs and things like that, but this is a big thing to consider. If you've got someone that's dirt poor with no assets, he's judgment proof. There's really no sense filing a lawsuit against him. All right, again, we kept it right at about a half an hour, which is where I want to keep it. We'll pick up with Chapter 4 whenever you're ready. I'll have that up. Have a good night, good day, good morning.